Okay, good morning everyone and welcome to Wednesday morning's breakfast seminar. Today we are joined by Conor Ahern, Consultant Solicitor for Silver Ash, who's going to be doing a new topic in his QS series covering retention. As always, few housekeeping notes. Can you please submit any questions through the Q&A and chat facilities in the bottom toolbar there? And Conor will endeavour to answer as many of these as possible at the end of the session. And again, as always, Conor is always happy to answer any direct questions that you have that you might not want to raise in an open forum. Email him at conorahern@silverllp.com and he will answer those directly for you. Just also a quick note, certificates for today and certificates for seminars last week. We are slightly backed up as we are relocating currently, but we will be catching up again next week. So certificates for today and any of last week's that you're missing will be out to you by next week, by Friday at the latest. So thank you for your patience. Right, without any further ado, Mr. Ahern, the floor is yours. I will hand over.
Great, great. Thanks very much, Julie. Good morning, everyone. Yeah, you're all welcome to the latest topic in what we call the QS series. Nice topic this morning. We're going to look at retention and some of the principles around retention, some tips around how to manage it on your contracts, and also just like crystal balling into seeing, you know, where will we go with retention in the future. I mean, it does cause issues, and I think if we were to consider the potential solutions to those problems in detail, they're actually not that difficult to fix. So we'll conclude on that point. Yeah, so this morning, so we get going now. So this is a bit about me, a bit of background there. Yeah, as Julie said, look, if you got any questions, you can stick them in the chat box. We'll get to them at the end. And also bear in mind, you know, it's educational rather than, I guess, hard legal advice. If you need anything, if there's anything appropriate to your particular project, you know, please feel free to send me an email. I'll happily come back to you. Great. So the agenda today, look, we're going to look at some origins. You know, where does retention come from, or you know, when do we start to see retention in our contracts? Look at what the contract says. That'll be a brief overview about the main forms of contract and how they treat retention. We look at what a fiduciary duty is. This is an important term in the JCT contracts, and we'll look at. I'll just explain about what that actually means, because the principle behind it is good. It's just the putting it into practice has been difficult. Look at the release of retention. Obviously, you know, the key trigger points for the release. Some points to bear in mind if you're negotiating your own contract. That's at the point of, you know, a pre-contract, and just some tips there. How to deal with retention at final account. You know, you're going in, if you want to try and wrap up your final account deal, not leave any money on the table. We'll cover that, and then also just some changes on the way. There's a new bill that was being proposed. It hasn't gone through yet. We'll have a look at that and just see also how they deal with retention in other jurisdictions, and see, you know, what is the right position, you know, for the UK. Okay, great. So, you know, retention, you know, what is it? So retention is a percentage of the value of the work, you know, held until completion of making good of defects. So retention is not a complicated concept by any means, and is very well known in the construction industry. Lord Denning and Hennig versus Isaacs back in 1952. So he said entire performance is usually a condition precedent to payment of the retention money, but not, of course, to the progress payments. The contractor is entitled to payment pro rata as the work proceeds, less the deduction for retention money. But he is not entitled to the retention money until the work is entirely finished without defects or omissions. So there you have, you know, Lord Denning almost 70 years ago, you know, explaining what retention is, when it becomes due, and, you know, by and large, this is a still good law, still what applies in our construction contracts today. So that's almost like one of the first references to retention that we have in CASO. So what does the contract say? So taking some examples here. So the JCT Design and Build 2016, we'll start with this one. So in JCT, it says the retention which the employer may deduct and retain shall be subject to the following rules. The employer's interest is fiduciary as trustee for the contractor, but without obligation to reinvest. Now, fiduciary duty, I'll discuss that in a bit more detail shortly, but just bear that concept in mind. It's very important. The employer shall place the retention in a separate bank account and notify the contractor. The employer is entitled to the interest that accrues on the retention. So that says the employer must put the retention into a separate bank account and then notify the contractor when he has done so. And the employer is entitled to the interest that accrues on the retention. So that's fair enough that the employer, retains the interest, but what it does require is that the payment is made into the separate bank account. As we all know in industry, it's more often the case that the retention remains in the employer's bank account and effectively treats it as his own and just falls in with the rest of the cash in the account that forms the basis of his own cash flow. I mean, very rarely, if ever, if at all, does it happen that the retention is making that separate payment. But that's a very important, it is an important principle to bear in mind if we are to, resolve issues around retention that does need to be resolved. It does cause issues, and they come up time and time again. Something needs to be done about this. Okay, prior to the notice of completion of making good, the retention percentage may be deducted where the works have not achieved practical completion of any sections that are incomplete. Half the retention may be held where the works have achieved PC, but the notice of completion of making good has not been issued. So that's where you have the retention at PC, and then the second half is retained until the certificate of making good defects has been issued. Okay, so that's the JCT. It's an abbreviated point. That's what it means. So that's the abbreviated version of the JCT contract. Okay, so moving on to NEC4, and we look at the position there. Again, this is an abbreviated kind of summary of what the clause actually says. I think it's X16 in NEC. It says that after the price for work done has reached a retention-free amount, an amount is retained each month until the earlier of either completion of the works or the date when the employer takes over the whole of the works. The amount retained is halved in the assessment made after the completion of the whole of the works and the date when the employer has taken over the works. So that's, again, it's saying that he keeps the retention until PC. Again, similar to JCT, he's keeping the rest of it then until the making good defects period has expired. But note that there's no reference to a separate payment being made, and there's no reference to any fiduciary duty either, as we saw earlier in the JCT. Quite why NEC doesn't address those points, is unclear. It could do so, and I think for reasons we'll come on to later on, it probably should. Moving on to the FIDIC Red Book, FIDIC 2017. Again, their position on retention is that after the issue of taking over certificate for the works, the contractor shall include the first half of retention in the next statement. After the issue of taking goods cert for a section, contractor shall include a relevant percentage in the next statement. So again, it's contemplating completion of sections, and it's contemplating the release of your retention on the practical completion of those relevant sections. After the expiry of the defects notification period, the contractor shall be entitled to include the second half of the retention money. So again, in the defects, you get the second half of the retention. The engineer shall certify such amounts if the works are free from defects. If defects are present, the engineer shall withhold an estimate of the cost in order to rectify. So again, duty is for the engineer to certify the retention. Obviously, if there are defects there, genuine defects, the engineer is entitled to withhold money in order to ensure that the works are done either by the contractor or by another contractor if necessary. So again, that's that's the position generally in JCT NEC as well. I mean, if there are defects there, generally, you are entitled to withhold money from the retention, and that's generally how it's used. So yeah, but you can see again in FIDIC, no separate payment and no fiduciary duty. So what is fiduciary duty? What is it? So what it is retention held on trust by the paying party. Now it requires the paying party to deposit retention into a separate bank account at the same time as the payment. Again, just thinking about the JCT wording is that the employer owes the contractor a fiduciary duty on the retention, and once retention is held, that retention is supposed to be deposited into a separate account. You can see this elaborate PowerPoint sketch that I've done just to illustrate exactly what it means. It's pretty basic. It's a basic concept. It's just amazing how how it gets confused, or how people can't make that separate payment. I mean, this obviously envisages a £100 payment with 3% retention. I mean, got to make two separate payments, and that's the whole idea behind it. Okay, so fiduciary duty. So what it was considered in the case of Rhea Construction versus Lampeter Meat Company, and in that case, it was decided that the employer's interest in any amounts retained shall be fiduciary as trustee for the contractor, but without obligation to invest, and the contractor's beneficial interest therein shall be subject only to the right of the employer to have recourse thereto from time to time for payment of any amount which he is entitled to under the provisions of this contract, to deduct from any sums due or to become due to the contractor. Again, this is 1979. This is 40 years ago. The concept still remains. And key point is that, again, a fiduciary duty. The court in that case concluded that when construed in the context of the agreement as a whole, the employer is obliged to set aside the appropriate sum in a separate trust account. The clause's purpose was to protect both the employer and the contractor against the risk of insolvency of the other. So again, we're coming on to a key point as well, is, this risk of insolvency. I mean, if the retention payment, is not made from the employer's bank account to a separate bank account, then obviously, it's going to be very hard to identify the retention money in the event that the employer becomes insolvent. Here it's actually contemplating the risk of insolvency either way as well, because if the retention is the contractor's retention is in the separate bank account and the contractor himself becomes insolvent, well then it's clear where the retention money is, and the employer will usually be able to, obviously depending on the wording of the contract, be able to reclaim that money and use it against obviously delays as a result of the contractor's insolvency, or obviously any defective work that the contractor may have carried out up until that point. So yeah, a good case there, Rhea versus Lampeter, is interesting, and it just confirms the point that which is where JCT language is derived from by and large. Just a final point on the fiduciary duty is that it's become more and more common that it's been frequently amended by schedule of amendments. So if you watch out for your next contract, the JCT contract, but by and large, you'll often see that the fiduciary duty obligation is actually deleted. Again, questionable as to the logic behind that, because look, obviously it's there to protect the employer, but I mean, it does go against the spirit of what the JCT language is in fact trying to do. Yeah, so just watch out. It's just an interesting one. Just you will, like, if you are reviewing a contract in the near future, just watch out for that one. It will generally, most of the schedules that are being issued now are deleting that duty. So yeah, just a tip there if you watch out for it. Okay, so release of retention. So this is the the next section. So the release of retention, it's important for many reasons. These are are pretty much the main ones. So risk of an upstream insolvency, as I was saying earlier, on the insolvency point that was touched on in REAC. Bear in mind, Section 113 of the Housing Grants Construction Regeneration Act 1996, because under Section 113, that confirms if a party up the chain has become insolvent, then so long as the contractor hasn't been paid for any of the work, the obligation to pay the subcontractor stops. So what that's saying is that if I'm a subcontractor and the employer has become insolvent, then if the contractor in the middle hasn't received that retention money, then there is no obligation on them to pay the subcontractor any of the retention money which the contractor itself hasn't received. So that's always a risk, and it does happen, and it's very difficult to make a case afterwards, because it's there in the statute. It's very you're going to struggle to try and overcome that. The risk of insolvency between the parties, again, that's always a risk, because either the contractor, the employer, any one of the parties can become insolvent at any time. If the money is in a separate bank account, then the money the retention would just get washed up, and all the rest of the assets. Indeed, if there is any money available at the very end, which more often than not there isn't. So again, just that risk of insolvency, very important. And just the unclear wording leads to greater time and money input in order to recover. Again, I will come on to this when you're negotiating the contract, but if it's unclear how you're going to release the retention, it makes it very easy for the paying party to find a reason why you shouldn't be paid the retention. So again, just make it clear as to the importance of the release mechanisms under the contract. Because what you don't want to do is have to get into a technical argument at the end. Usually won't happen at PC. It's usually always around the second release of the retention that this will become an issue. Just very important as well. Really, like when you are signing your contract, you really have to start with the end in mind, and the release of retention is obviously a key point to be considered. As I said, in practice, is usually the second retention payment that proves to be problematic. And this was reviewed in the recent case of D.R. Jones, Yeovil versus Stepping Stone Group. This was a case in the TCC only last year. So, retention is still, it's amazing to think that, there are cases that still come before the courts that actually, have to deal with retention as one of the key principles. So some background here is that the claimant is D.R. Jones, which was a building contractor, and the defendant was Stepping Stone, which is a developer. They had agreed 3 contracts, and retention had been paid under 2 of those contracts. Obviously, so the retention was withheld on the 3rd contract as the defects were allegedly not made good. Excuse me. So D.R. Jones rectified the defects, and Stepping Stone should have issued a cert round about mid-2016. Stepping Stone counterclaimed for losses associated with failure to rectify some defects, and sought to, basically deduct sums that turned out to be quite spurious on the facts. And ultimately, as we will see, they were unsuccessful in doing so. So in D.R. Jones versus Stepping Stone, it was held that if a certificate of making good should have been issued, the contractor is entitled to proceed on the basis that it has been issued. This is decided on the facts and evidence provided by the parties. Now, so that's a very useful point to have in the back of your minds, because if a certificate of making good hasn't been issued, then the contractor is entitled to to proceed as if it had been, because it's actually quite rare in industry that we see the actual certificate of making good being properly issued. So it's just a good, that's the position. If you haven't got your certificate of making good, of making good is the position. It is a position that you have to proceed on the basis that it has been. Sorry. It was held in the case that retention is money earned by a contractor, and sums cannot be deducted without accurate set-off or counterclaims. So again, it's just the need for accurate set-off. I mean, if there are genuine defects there, then absolutely, I mean, like an employer or a paying party should be entitled to withhold that money until the defects are rectified. But you got to have the proper records. You got to have, your photographic records, emails as well, giving notice during the defects period. And if you have that, then there's no reason why you can't why you can't deduct money from the retention. Next point. So while Stepping Stone had notified DR Jones of the defects on time, the court found that the evidence being proposed was described as hopelessly vague. So again, it's a good example of that this happens quite frequently, that the evidence is in fact hopelessly vague, and the paying party is trying to vexatiously hold on to the retention money in order to attain a commercial benefit. The evidence confirms that the certificate of making good should have been issued in mid-2016, and as a result, DR Jones is entitled to the retention and plus the interest as well. So Stepping Stone had to pay the interest on the retention also. Now it's it's a good example of I guess very, I suppose, common issues that occur around retention that we constantly see as solicitors, is where information is the employer has issued information which is just not good enough to justify reasons why amounts are being deducted from the contractor's retention. The court is making it clear that you cannot do that. You cannot deduct unless you have accurate set-off or counterclaims, or proper records, including proper notice. And like I said earlier, it should, absolutely, it is the employer's right to deduct money from the retention if defects remain. But if that's the course of action you wish to take, you have to be very careful in the information that you prepare, and ensure that it is accurate, that it does, will satisfy the needs of a court should it get tested. And unfortunately, in this case, the court wasn't slow in considering the information as being hopelessly vague, which basically means, that the money was being withheld vexatiously. The employer, I suppose, looking for reasons why he shouldn't pay the retention. As I said, in order to just keep the money as their own. It does happen, but again, good reminder from the court as to what happens, in the event that these circumstances should arise. Okay, so final point on the release is that, what if there is no express term for the release? And this was decided back in 2011, the case of PC Harrington versus Tyroddy. It was decided in that case that the court made it clear that it ought to be paid within a reasonable period of time following completion of the works. So, nothing too spectacular about that. But again, if you end up in this situation, you'll get into discussions around, what is a reasonable time, for completion. It's just, you're starting on the back foot. You're relying on this as a I suppose as a backup position, really. It is very important to try and that you try and avoid these type situations and make sure that it is crystal clear, or as clear as it can be under your contracts, as to the specific points when the retention ought to be released. Okay, moving on to the next section. So negotiating your contract. Right, so the parties are free to agree to retention in their contracts. Indeed, if there is to be any retention, which there are some contracts where it's not really appropriate for retention to be held at all. So as we know, the retention is usually expressed as a percentage. So usually it's either 5% or 3%. It can also be 0%, as I was saying, if there is no retention being withheld. Also, but you can, you know, and I have done it in the past when negotiating contracts, that you can agree to retention as a value as well. So basically, if you agree what a, you know, a cap, a value cap, where, you know, the employer gets to withhold retention up to the value of, you know, of £100,000, say, and then after that, there's no retention held on any future payments once it hits the cap. That's also, I mean, again, like, you know, your retention is just, it's another aspect of your overall negotiation with your client. And it's good to have these, you know, these options available in order to, you know, make sure that you're kind of limiting your exposure in relation to the amount of retention that can be held, but also that it's clear as to, you know, as to what that agreement is. And if you are reducing your exposure on retention, well, then, you know, you're going to have less to, you know, less of an issue. You know, the smaller the amount generally, the less of an issue it can be to get paid. That's just a bit of a general rule. It obviously doesn't apply in all the circumstances, but if you have a cap, it does help. It does help to just to reduce your exposure. You know, so you can end up, and often, you know, if you're considering a cap, you know, you're aiming for like, you know, 1%, 2%, just to have some, so the employer has some comfort there, but just that it's not, you know, or, you know, that it's not too much of a burden on the contractor, particularly given as, you know, as it's coming directly out of the contractor's cash flow as well. So just bear that in mind. It's good, you know, a good tip, one that I found to be of a lot of use when negotiating contracts. You know, in days, not so much as a solicitor, but very much so as, you know, in my days as a QS, definitely it was always a good option to consider as part of the overall negotiations. You're free to agree to, you know, the terms of release also. So, yeah, you know, if you're a sub, you know, you got to watch when, you know, that release trigger. You know, watch out for does your retention, first half retention, does it get released on say the employer's PC, on their practical completion, or is it on the contractor's practical completion? It's actually even more important for a subcontractor, because, you know, does the first half release get paid on the subcontractor's practical completion? Often it's the case that, you know, the main contractor will want the first release to be at the same point when the first release is made under the main contract. So again, it's just very important. You got to watch out for that, because if you don't catch it, you will have to wait until the main contractor has achieved his PC, and there are other issues around that. So yeah, just terms to watch out for. Also look at the you know, the rectification period. Again, it's around the, you know, the terms of release. So you got to look at the, you know, the duration of the rectification period. That's actually, I'm thinking of a, you know, JCT contract. That rectification period is separate to your retention mechanism effectively. So if you have for example, a 24-month rectification period, which is pretty common, well then, but you're not, you know, you won't be entitled to, unless you've agreed something else, it's going to be deemed that the retention can be held for the 24 months following the following practical completion. So very important, you know, point to watch out for when you are negotiating your contract. The next point then is, you know, are there sections, or is there just one overall completion date? It's a very important point, because if there are, you know, sections, if you have section completion under your contract, then if you look at the section completion clauses in the JCT, it actually, you know, other aspects such as, you know, for example, your LADs. If you're in a section completion type scenario, you hit section completion, then in an unamended JCT, basically your LADs are supposed to be prorated down, in order to, you know, reflect the fact that some of the sections have been completed. The same principle doesn't apply to in the standard form to retention. So you've got to watch out for that. And again, in the release clause for the retention, you will want the contract to be clear that you get paid the first half of the retention on completion of each section. It's because, again, if you watch out for the wording, it will say that you get paid it on completion of the final section. And again, it's cash flow for the contractor that that they have to go without for for that longer period. So it's just very important to watch out for that. If you are working to sections in your contract, then very important to try and negotiate the retention payments to get released on the completion of each section, because the standard form won't say that. So it's one you kind of have to bring up yourself. Next point is to watch out for contract works carried out significantly later than the main works. Yeah, this was this was a classic that I used to deal with, because being involved with a groundworks contractor, and often it was the case that we would have to do external works as well at the very end. So what happens to the retention for the period in between completion of the groundworks, whilst you're waiting for the external works to become available? Again, in order to minimize your exposure, you wouldn't want the entire retention on the groundworks phase to be withheld until practical completion of the external works. So it's just understanding the detail that's behind understanding your program and how that's going to work. Because again, it's cash flow. If your entire retention on the groundworks phase is being withheld for another 12 or 18 months due to the external works, then it's just not ideal for a contractor or a subcontractor, but mainly a subcontractor, because the main contractor is obviously going to remain on site to ensure that the frame, the fit out and everything else is built, but all the while the groundwork subcontractor is hanging out for his amounts under the first phase, under the groundworks phase. So it's just a heads up to watch out for that. I'm sure groundworks QSs will come across that quite frequently, and I'm sure that they are covering it. But it's definitely one it does require thought, and it does require consideration up front as well, to make sure that your cash flow is not being overly restricted by not having a proper release term in the contract to begin with. So do watch out for it. Demolition contract here. So again, I put this in. I mean, demolition is it's a kind of a classic. It's a conversation we've had many times. That is demolition as a permanent works, or is it as a temporary works? And most demolition contractors will argue that the retention, the demolition is a temporary works aspect, and therefore why would you need to withhold retention on that? Because in effect, what defects could possibly be discovered later on. It's a good point. It's always one that that comes up. It's one to be one to be considered. If I'm a demolition subcontractor, I'll argue that the retention should be zero. Obviously, from a main contractor's point of view, that's not ideal. This can get complicated if the demolition contractor is carrying out some temporary works, which is going to be released by one of the follow-on contractors, be it the groundworks or the RC frame contractor, especially where even existing building. Used to deal with it quite a bit on facade retention projects here in London. So so that's it. That makes it more difficult, because you in fact have it's still temporary works, but if there are defects discovered in the facade retention later and there is no retention, then the contractor will not have any recourse to the. I mean, he won't have any money held on the demolition contractor. He can still try and get him back to site, but it's more difficult, as we all know, to get somebody back to site when you don't have any payments due now or in the future to them. So it's just another point to bear in mind. It's one that gets discussed quite a bit. It's an interesting conversation, and whether it's held or not does very much depend on the facts and scope of that demolition contract itself. Also, when you're negotiating your contract, you can consider a retention bond. These may be used as an alternative, and both JCT and NEC consider them to be valid options. So yeah, I mean, even in the schedules in both those contracts, there is a template retention bond wording included also. One of them, they're not used very often, retention bonds. Main reason by that, and this was in some research carried out on the topic, is that they can be expensive and the cost is borne by the party lower down the chain. So again, the retention bond money will have to be paid up front, and that's a hit for the subcontractor usually to bear. The benefit is that the contractor doesn't get to hold the retention throughout the contract then. So yeah, look, it depends on the circumstances, but again, it's just one aspect to bear in mind in when negotiating your contract. I know a lot of contractors do use retention bonds very effectively, and they're absolutely a means to they do serve a purpose, because the contractor is protected, that if the subcontractor has defects or needs to come back to site and the subcontractor kind of refuses to do so, then you can call the retention bond, and the bondsman will generally have rights to, if the subcontractor hasn't acted in a professional way. Generally the terms that sit with the bondsman will be that the bondsman will have right to recourse against the subcontractor. So again, it's another means of getting ensuring performance, which is what what we really care about here, is performance and proper performance of the contract itself. So yeah, do bear in mind those retention bonds, because they absolutely can serve a purpose and are very much in the drafting of both the the JCT and NEC contracts. Excuse me. Okay, so final account. So now we've done all our work. We're at the final account stage, and it's always on the table that what are we going to do with the retention? I mean, so do we include it as part of the the final settlement? And final settlement will be once practical completion has been achieved. I mean, and provided the wording in the contract is clear, the release of the first half of the retention shouldn't be controversial. It will always be about that second half. And again, it's about, when you negotiate the contract, have the second half really in your minds, because, yeah, as I said here, clarify release of the second retention amount. Because if it's unclear, it will make it harder for you later on. And, and in any negotiation, the contractor will sense that if if it's a contractor-subcontractor relationship. And as a result, you'll be, if you want to do a deal under retention, there's pretty much always a deal to be done on it. But if the terms of release aren't clear, then you're not going to get as good a deal as what you otherwise could. And that's on the final point. So like early release will usually require consideration for the better bargain. And again, it goes back to the principle to keep the retention amount as low as you possibly can. Because early release, so when I say early release, I'm talking about that second payment. For any contract, most contractors will have the discussion, and will want to, are happy to consider early release of retention, but obviously they're going to want some consideration, they're going to want some benefit for paying that second retention amount early. So you got to think about that. Generally it does involve leaving some of the retention money on the table, which depends on the circumstances. A lot of it, to be honest, depends on who your client is, because if you are in a situation where you've got a one-off client, or like an SPV set up for the project, if I was faced with that situation, I'd be more inclined to try and get wrap the second payment in the final account, because you don't know what's going to happen. it does happen where, an SPV can just, shut down, and, some of the contractors may not have been paid all their money. So my attitude with that is that, classic saying is a bird in the hand is worth two in the bush, is what we used to say. But again, their consideration will be required. It's absolutely a discussion that has to be had. But if you're going into that negotiation, go in with a strong hand, and that goes back to the original contract. Go in with a very clear clause that provides for the release of the second payment. Okay, so final section. So are there changes on the way? So there is a scheme. It's called the retention deposit scheme that's being discussed at the moment. Excuse me. So this is similar to a tenant deposit scheme on rental property, and that has been in place since the 6th of April 2007. The idea behind the scheme is that it is compulsory for businesses that hold retention under construction contracts. It has been discussed significantly in detail in industry, and it's very much an option that's favoured by small to medium-sized companies. And in fact, a construction retention deposit scheme bill has been drafted. So we'll look at some of the aim, like the construction retention deposits scheme bill is aimed at amending Section 111 of the Construction Act 96 to impose a mandatory retention deposit scheme on the parties. A payer who failed to comply with those requirements will be required to refund the cash retention to the payee within 7 working days from when the cash retention was withheld. So that's basically putting the obligation on the paying party to make the separate deposit, which is, again, it goes back to the fiduciary duty. It goes back to, the original. If you look at the unamended JCT wording, that's what the actual contract actually says. So, this is like another means to, enforce that position and make sure that that's in fact what parties are doing. Look to extend the meaning of construction contract in Section 104 of the Construction Act 96 and include any contract created to have a similar effect as a construction contract. Again, it's just, bolstering, the bill in statute and linking it back to the Construction Act as well. It's ought to define a cash retention as monies which are withheld from monies which would otherwise be due under a construction contract. So the cash retention, again, it's basically that money that it's envisaged to be sitting in that separate bank account, which should be done when the payment is made by the contractor or the employer, whatever the case may be. Examples from other countries. So, in the US, France, Germany, they favour retention trusts. In Australia, projects over $20 million require a trust account as well. And in New Zealand, money is held on trust as well. I mean, again, it's not real difference to, that's really what the principle, ought to be here in the UK also. It's just that, like the that deposit scheme bill will make it clearer exactly what the obligations should be. I suppose, we hope that type scheme will come into place sooner rather than later, because it makes sense. It will avoid, the idea would be that it would reduce the number of disputes that are held, or that commonly occur around the second release of the retention, and it will make for a more efficient industry basically, and there's no reason why it can't be done. So hopefully we see further developments in this in time, because they would be very welcome. Okay, so we're going to wrap it up there. I mean, we've covered, we looked at the origins of retention. We've looked at the fiduciary duty. We've looked at, what you got to do when negotiating your contract, what you got to do, if you're, at final account, and also just considering some changes on the way. So, look, thanks all for tuning in, and look, I'll be delighted to take some questions now. So yeah, I'll hand you back to Julie.
Okay, and we do indeed have some questions. They have been coming in thick and fast. Question 1. As a contractor, in reference to retention monies being paid into a separate bank account, how would I be able to audit if the monies are actually paid into a separate account, and what is recourse? What is the recourse if this is not completed?
Yeah, look, very, great question, and this is exactly what is being contemplated in the retention bill. Is that, say I can basically ask, if I'm a contractor, I can ask basically the employer to show me that that the money has in fact been paid into that separate bank account. And if that's not provided to me within 7 days, then basically that money will become due. So what that does is it puts the obligation on the employer, and it also gives the contractor the right to ask for proof at any time during the course of the contract, anytime following basically the first payment, which would be a good time to do it, because that way, the employer will see that you're serious about the retention. It's obviously a very key aspect of the contract. It's contractors' money, so it's obviously going to be a key aspect of the contract, particularly at the moment as well, because what we're seeing is that, profit margins on projects are really, it's difficult out there at the moment. So, the retention, 3% retention, like that often is the case that could be the contractor's profit on a project. So just to go back to the point is that, you'd want to do that, and the bill would give the right to the contractor to require the employer to put that money into the separate bank account. If it isn't there, then, there is a bit of work to be done in relation to what happens then. But, employers will not want to have these conversations with each and every contractor. It will be easier for the employer to just set up these separate accounts and start treating the retention properly from the beginning, which is really the purpose behind the bill. At the moment, how could you audit the monies are actually paid into the separate account? There's, again, there's no real formal process, for doing so. You can by all means request to see that, but again, it goes back to, you want to make sure that that is in fact what the employer is obliged to do under the contract, because if it's not there in black and white that he has to make that separate payment, then there is, the obligation doesn't exist. If it does exist, I'd recommend asking the employer to provide proof, and I just start having a discussion and just emphasizing the importance of it. Are you going to dispute it? That questionable, because it would depend on the amount. But my tactic would be one way to do it is that you can just raise it with the employer early doors, just so he can treat it properly, and basically once they've set up that account, you can keep asking for it every month after that, and it's just making sure that the money is treated as your own, and it's identifiable should something unfortunate happen later on down the line, like an insolvency. That's pretty much it, Julie, at the moment.
Okay. Someone else is asking, under JCT, if an employer does not set aside the retention monies in a separate bank account, would this constitute a material breach of contract?
Yeah. Look, technically it is a breach of contract. Is it material? Not so sure. Would it be ground? I wouldn't be considered to be, grounds for repudiatory breach or anything like that. Or nor would it go really to the root of the contract if that, if the separate bank account wasn't in place. Again, it's a means of of discussing and keeping an eye on your retention throughout the contract. I wouldn't fancy taking the case that it's a material breach. I just think it's the wording, particularly in the JCT form as we looked at earlier, is that you just remind the employer of his obligations, that's what that you've entered into this contract, and that's what the contract requires them to do. And I'd be sending my my request in to to get them to set up that separate bank account, and enforcing it that way, Julie, you know.
Okay. Someone else is saying, do there need to be separate bank accounts for each contract for the employer that the employer enters into, or does an account titled contractor retention account suffice?
Yeah, there's ideally, you know, if you're, you know, employer contractor relation, me as a contractor, I would want, you know, my own kind of retention, you know, separate retention account, because the problem is that, you know, if you just had one separate account and put all of, you know, all of the various contractors amounts into it, you know, it can get like, you know, it can become quite confusing. The idea is that, you know, the separate bank account is linked to payments under, you know, one individual contract, and it's clear to see how much has been paid, how much has been held in retention, and that money held in retention is effectively the contractors. It's just the employer is holding it until such time as PC has been achieved, and making good of defects has expired also. So yeah.
Well, that person's asking, they just said currently on their projects, the employer will be entering into at least 50 separate JCT contracts, hence the question.
Look, yeah, that's it. I mean, you know, that's the, you know, looking at the wording, you know, if there's an unamended JCT wording in place with every contractor, you know, that, I mean, because you got to think about how practical it is to have it, you know, to have it that way. I don't know of any authority that says the employer, you know, in such circumstances would have to have a separate bank account for each and every contractor, because as you can see, administratively, that's a massive burden for the employer. Nightmare. Yeah. And you know, and I'm not sure, you know, that's what, you know, we had in mind, you know, that the JCT drafting had in mind, you know, when it's, you know, worded in its current capacity. You know, again, it's for the parties to agree. I mean, you know, what's the position going to be? If you're going to be entering into those contracts, you've got a chance to do something about it, because the contracts haven't already been entered into. So, yeah, you know, like, I mean, because at the moment, the way that's going to happen is that, you know, the employer is going to pay, you know, is going to make the payments, you know, following the deduction of retention, and leave the money in the same bank account from which the main payment was made. You know, that's generally the way, you know, it's how it works. I mean, really, it's for, you know, it's for the contractors who the employer will be engaging to raise the points and to raise the point about the separate bank account, because really it's in their interest. You know, the benefit of that separate bank account is really for the contractor, not so much the employer. So it's really for the contractors to take that. And, you know, that's kind of been the theme throughout here, as I'm trying to make it, you know, the employers will continue to withhold retention like they've always done, like they've done from day one. And I don't blame the employers for doing that. The reality is that you know, it's the contractors and the subcontractors that need to be aware of this, of what the contracts say, and, you know, bring these points to their employer to make sure that they are, you know, carefully managing and monitoring their retention money at all time. If you don't do that, you'll face the consequences at the end, and you won't get as good a result as you would otherwise should have achieved.
Okay. There's a fair few questions still left. Sorry about this, Conor, but everyone's has been asking lots of questions, raised a lot of interest this topic. Under English law, what happens if the employer refuses to issue the takeover certificate and has not given any notice of defects? Under the contract, the retention can only be released once the takeover certificate is issued.
Yeah, good question. I think we covered this in one of the cases. It said that it was last year's case. It was DR Jones versus Stepping Stone. And what that said was that if the employer, you know, just say, for example, the employer should have issued the takeover certificate, refuses to issue the takeover certificate and not given any notice of defects. I mean, if the defects period has expired and he's not, I mean, if he refuses, you know, if he just fails to issue, what that case said in DR Jones was that the contractor can proceed on the basis that the certificate has been issued. But that's basically where, through the, the passing of time, that the defects period has expired. It's like, it's a separate point to think that that the employer has knowingly refused to issue certificates.
Mm.
Like in that case, there's surely got to be, they've obviously got to have reason as to the refusal. And basically, they're disagreeing that the works have either achieved PC or that the defects have all been rectified. In such circumstances, that's more of a dispute rather than an issue over retention as such. Like, because that's knowingly, that's like almost like a crystallization of dispute where they absolutely refuse to either, accept PC or accept that the defects have all been rectified. Look, if that person has, something specific that they want to ask, send me an email if there's a specific point on it, because that sounds more of a dispute than an issue of retention, to be honest with you.
Okay. Someone else is saying, what can be done in terms of the release of the second half of retention if the contractor has not rectified all defects, even 12 months after practical completion? The contractor has contacted the employer to try and access the building to ascertain the defects and rectify accordingly, but they are not able to access the site. The employer will not allow because of COVID. How does COVID impact this? The contractor has expressed that they feel this is delaying payment of remaining retention, and it's under a JCT DNB 2016 contract.
Right, yeah. Fair issue. It's it's one that I imagine is happening quite a bit out there at the moment, because there's genuine concern on both sides, because the employer obviously doesn't want additional contractors in, due to COVID, and obviously everybody has to be adhering to the to the COVID protocols that are in place at the moment. It kind of does depend on the facts, Julie. I mean, it depends on the scope of the defects, and it depends on what the access requirements are really in order to be able to rectify those defects. And it comes down to, is it just a simple case of kind of repairing a light, a light switch, or something like that, or is it something that's serious, that's really defective, that that goes to simply that the contract cannot possibly be performed on the basis of the defects that remain. It's a difficult one, because obviously again, adhering to the COVID procedure, the employer sounds like he's got a reasonable case to deny and deny fairly at the moment. I mean, again, the contract doesn't contemplate this. It doesn't contemplate a lot associated with COVID. So it would seem like arguably does the defects period get postponed temporarily until the time period for COVID passes, and God only knows when that's going to be as well, by the way. So
yeah,
it's a difficult one. I mean, it will boil down to the specifics that are present in that case. And I mean, again, if they want to follow up with that, just ping me an email. I'll come back to them and try and steer them in the right direction. Okay.
Yeah, no problem. Okay, someone else is asking, if the employer's agent vexatiously deducts against retention, does it invalidate the final certificate?
Vexatiously doesn't invalidate. I mean, vexatiously, deducting, again, shouldn't. I mean, that's not what. Again, a reminder that we shouldn't, that any party shouldn't be doing that, is in that case last year of DR Jones versus Stepping Stone as well. Does it invalidate the final certificate? I mean, again, Julie, it depends on the nature of the defects, or what the deductions relate to. I mean, I'm just around final certificate, I'm unsure as to whether that's the is that, I presume that means the making good of defects. certificate is what's meant by there. If he's vexatiously deducting, again, it sounds like the parties are going to have an issue, because, again, like last year, courts dealt with the point, you can't be vexatiously deducting money just because the employer wants to hold on to the cash. This comes back to the point that, I guess it's almost like if the employer is paying that money separately into that separate bank account, well, then it's unlikely that that he's going to continue to treat that money as his own, or that the idea would be that it would avoid disputes of this nature. But it happens too often in industry that a project gets to PC or in the defects, the employer maybe hasn't made as much money as what they had hoped. They're now scampering around looking for reasons why they don't have to pay the retention. We see it all. It happens all too frequently, Julie, that we're dealing with disputes over retention because parties want to vexatiously withhold. Can't do that. So it sounds like there may be grounds for dispute there as well.
Okay.
Unfortunately, which the retention bill hopes to kind of reduce the potential for such disputes in the future.
Okay, I'm just smiling at your description of the employer as scampering around.
Yeah.
I learn something new in your seminars. We've got time for one final question, and I'm going to pass you the details of those questions that haven't yet been answered, so you can answer them directly if that's okay.
Yeah.
But this one here, does a contractor have to pay his subcontractors the remaining retention if his own retention has not been paid or released by the contractor after over 12 months after PC?
Yeah, good question. Well, you see, the subcontract is a separate agreement between the subcontractor and the contractor. I mean, if it is a situation where the contractor in his contracts, in the main contract with the employer, has agreed a longer, a longer period, just say a longer defects period with the employer, then and agrees a shorter one with the subcontractor, well, then it will be the case that the subcontractor will be entitled to have his retention released before the contractor has his own retention released from the employer. Again, that they're two separate contracts. There's no back-to-back or pay when paid was outlawed in the Construction Act. They're separate agreements. They stand on their own 2 feet. And yeah, again, not a great position for a contractor, because he's had the opportunity. He's had the opportunity to negotiate his contract with the main contractor, and look, he has the opportunity to ensure that the subcontractors aren't getting paid before him either, because he's got a double whammy if he's paying out the retention, which he's not otherwise been paid by his employer. So look, to answer the question is, yeah, absolutely. The subcontractor is entitled to be paid before the contractor gets his, but that's down to the contractor to manage in the course of his own negotiations with both the employer and the subcontractor.
Okay. Well, as always, thank you very much, Conor. That's a really informative, and there's lots of feedback coming in saying really useful, lots of stuff that people didn't know. Retention seems to be a bit of a hot potato at the moment. The recording of this, if anyone wants to rewatch, just to re-emphasise stuff, will be available on our YouTube channel later today. And we will be seeing Conor again shortly for another of his QS series topics. In the meantime, everyone have a great day, and we will see you all again soon. Conor, I'll pass those questions to you. Thank you for your time.
Okay, great. Thanks, Julie. Thanks, everyone. Have a good day.
Take care.
Thank you. Bye.